Good morning, sir. My name is Diwaakar Dwivedi. I'm of section BBA, and my serial number is roll number 39, and I'm currently in my fourth semester. I'm presenting this for the company law video lecture assignment, and the two chapters that I'll be discussing are Memorandum of Association and the share capital. So let's come to our learning objectives. I'm sorry. Yeah. There are total 8 pointers that I'll be covering throughout this presentation. The first one being definition or defining Memorandum of Association and understanding its legal significance. Then we have explaining all 6 clauses of the MOA with examples. Then we'll be distinguishing between the MOA and the AOA, which is Articles of Association. Then we'll go through the different type of shares: authorized, issued, subscribed, and paid up. Then we'll be identifying and comparing equity shares and preference shares, explaining transfer and transmission of share with key differences, understanding the members' rights and the registration of members, and knowing the role of managing director as well as the whole-time director. Let's continue. The first part of our presentation would be MOA, the charter document of a company. So the first question that comes to our mind when we talk about MOA is what exactly is a MOA? So its legal definition can be described as the Memorandum of Association is a fundamental document of a company that defines its constitution and the scope of its powers. It establishes the relationship between the company and the outside world and specifies the objects or the objectives for which the company has been formed. And some documents or some important things to keep in mind while we're talking about MOA are the supreme document. The MOA is the company's supreme governing document. All company activity must remain within its scope. Any act beyond MOA is treated as ultra vires or void. So as we can understand, it's the somewhat of a constitution, we can describe it as, of a company, and everything should be followed up to the T. Otherwise, it can be considered as void or ultra vires. Then we have it. Then it's also known as the public document, or it could be not termed, but it could be said as the public document. MOA is filled with the registrar of companies and is accessible to the public. Any person dealing with the company is deemed to have a notice of its contents. So everything about a company or its MOA is accessible to the public for extra transparency of their activity or how they function. Then it's a mandatory document. No company can be incorporated under the Companies Act 2013 without a properly drafted and registered Memorandum of Association. I think it's very clear that any company that's allowed to work or that wants to work in a corporate market has to have an MOA so that they can function properly, or they are legally so that they legally abide by the rules which are set. Then we coming towards the binding of the members on members. Every subscriber to the MOA and every member of the company is bound by the terms of MOA as if they had signed it personally. So any person that's working for the company, who owns the company or is associated with the company, has to be bound by it, and they have to follow the rules and regulations that's mentioned in it, since anyone associated with the company is part of the company, and they should abide by the laws. And then we come towards the 6 clauses of the MOA. The first one being name clause. It's the official name and must end with a limited or private limited. And then we're coming towards the registered office clause, the state of incorporation and location of registered office. I think that's understood that we should mention the area or the exact location where the office was registered. And we come towards the object clause. The main objectives, ancillary objects, and the other lawful objects that will be associated with the company should be mentioned. Then there's the liability clause, the nature of members' liability by shares or by guarantee. Then there's the capital clause, any authorized share capital and division into share types. Then there's, I'm sorry, association clause, subscribers' declaration agreeing to the form of the company. Now we'll describe and talk about the first clause. I'm sorry. First and the second clause clearly. The clause 1, name clause. It has a rule that every company must have a name stated in the MOA, as it's quite understood that if anything that's working in the market should have a name to it, and it should be unique so it doesn't cause any legal implications in the future. There should be a suffix, a clear suffix such as public limited or any private limited, but it must end with a limited. And then there are some restrictions. Name must not be identical or similar to the existing company or trademark. Like I mentioned, you cannot have two similar companies with the same name or identical names even. Then there's change. It requires a special resolution plus central government approval. Then there's an example like Tata Motors Limited, Reliance Limited, and several other companies that have private limited or limited in their names. And it comes under the section 4, 1A of the Companies Act 2013. Coming to our second clause, the registered office. The purpose of it is to determine the state of incorporation of the company, like where all of the location of the company, where it's situated, and the High Court, all the legal proceedings filed in the High Court of the state of that state. So all of the work, all of the legal work or the framework that has to be done should be done in the High Court of that particular state where it's situated in. Then we're coming to the notice. Within 30 days of incorporation, the company must have an office so that they can start functioning or they can start their work out of that office. Then I'm sorry. Then there's change within same state, board resolution, different states, special resolution plus NCLT. The name and address must be displayed on all official documents so that they know, like the particular document belongs to that company and they don't get confused with any other document. And this comes under the section 12 of the Companies Act 2013. Moving on to our clause 3, the objects clause. The most important clause of the company, as mentioned here, of MOA, I'm sorry. The ultra vires doctrine, any act performed by the company that falls outside the scope of the objects clause is called an ultra vires act. It is null, void, and cannot be ratified even by unanimous resolution of all the shareholders, as it happened in the Ashbury Railway Carriage case in 1875. So any act performed by the company that falls outside of the object clause is called an ultra vires act. So basically, if anyone, in that case, like the Ashbury Railway Carriage case, the defendant or the accused had done something which fell outside the boundaries or the legal implications or the legality of the object clause of that company, it was deemed as null and void, and it could not be ratified or rectified even by unanimous resolution of all the shareholders. So let's discuss more on the topic. The main objectives of this object clause is to describe the primary purpose of the company for which it's incorporated. It must be specifically and clearly stated, whatever the object clause should be. They should be clearly specified and stated in that document. All the core business activities fall under this. Example, manufacturing corporation to manufacture and sell automobiles. So they should mention what their functioning should be or how they'll function. The company cannot carry on any business not listed here without amending the MOA. Then ancillary or incidental objects, activities necessary or incidental to the achievement of main objects should be mentioned. They do not need to be explicitly listed if naturally incidental. Example, opening bank accounts, having employees, leasing premises, must be connected to and support the main objects. So it should be connected and support the main objectives of that company. And it should broaden the operation flexibility within the scope of the main objectives. The other objectives should be any additional lawful objects the company may pursue in future should be mentioned. It cannot contradict or override the main objectives. I think that's quite understood that whatever you're doing should not contradict with your own work or the work you'll be doing in future. Otherwise, that may cause some legal problems. It should require special resolution to commence business under the other objectives. Gives the company flexibility for future diversification in case they want to diversify their work or they want to spread out their work more. They have an option if they choose to put it in the objects clause. Example, a manufacturing company listing trading as other objectives. Coming on to our fourth clause, fourth, fifth, and sixth exactly. Sorry. The fourth clause, which is the liability clause, states the nature of the liability of members limited by shares. Members liable only up to the unpaid amount on their shares. The members are only liable to the unpaid amount for their shares. Limited by guarantee, members liable up to the amount they guarantee in the event of winding up. So in case the company winds up, they are only liable to the amount of shares that they guarantee when the winding up happens. Then there's unlimited, members liable for all debts of the company, which is a rare case scenario. Then we're coming to our fifth clause, which is the capital clause. It states that the authorized nominal share capital of the company and its division into shares of fixed denomination uh, states that the authorized nominal. It states the authorized or the nominal share capital of the company and its division into shares of a fixed denomination. It could be further explained as with an example as the authorized capital of a company is 10 lakhs divided into 1 lakh equity shares of 10 rupees each. The clause sets up the upper ceiling of the company, and the company cannot issue shares beyond this without amending the MOA. So it basically states the budget cap or the cap which helps in determining or defining what's the certain limit up to which they can uh, they can divide the shares. And there's clause 6, the association clause, a declaration by the subscribers that they desire to be formed into a company and agree to take the stated number of shares. So it's basically a declaration when certain people subscribe to their shares or buy their shares, they have to be they have to agree to take this stated number of shares requirements. Minimum 2 subscribers for a private company, minimum 7 for the public company. Each subscriber must sign in the presence of a witness. The number of shares taken must be stated against each subscriber's name. This clause formally creates a bond of association among founding members. So here I'm just telling about or discussing the minimum requirements. Like it's 2 subscribers for a private company, 7 for a public company, and the the requirement during the signing is that it should be done in the presence of a witness, and the number of shares must be stated against each subscriber's name. So how many they've bought should be stated along with the name. This officially creates or formally creates a bond of association among the founding members and the subscribers. Moving forward with the next topic, which is the alteration of Memorandum of Association. The MOA, being the supreme document, it's not easy to alter. Different clauses have different procedures. All the alterations require passing of a special resolution at a general meeting. So I think it's understood that whenever we have to alter or make some changes in a supreme document of a company, like the documents which is basically the constitution of a company, we should keep certain things in mind so things don't go wrong legally or financially or in any certain way. First, we should also keep in mind the changes that we have to make or how it will affect the clauses of the company. So the changes by that we have to see or we have to keep in mind while changing the name clause are special resolution plus special resolution and the approval of central government, Ministry of Corporate Affairs, effective only after ROC issues a fresh certificate of incorporation. Then coming on to the next point, register office, same state. The special resolution sufficient. Notice to ROC within 30 days in Form INC 22. If the office is registered in a different state, there should be a special resolution plus confirmation of the NCLT, which is the National Company Law Tribunal, and the creditor or the employee objections must be addressed. Then coming to our next clause, which is objects clause. The special resolution, ROC must be notified. Company cannot commence abandon objectives without fresh special resolution. So they cannot leave their old objectives without mentioning or taking on the new fresh special resolution. Then we're talking about capital clause, the ordinary resolution for increase of authorized capital unless the AOA requires special resolution. The board resolution for consolidation, conversion, and cancellation. Then coming to our liability clause, only possible with special approval, converting from unlimited to limited requires consent of each member and creditor individually. So when we're talking about liability clause, it should be done under a special approval. Converting from unlimited to limited requires consent of every member and creditor individually. Moving on to our next topic, which is the comparison or uh, differentiating between the MOA and the AOA. The MOA is the charter or the supreme document of the company, whereas the AOA can be described as the bylaws governing internal management. So the MOA governs the overall working of the company, whereas the AOA just manages the internal management of the company or the laws that manage the internal management. Then coming towards the purpose, the MOA's purpose is to define the scope, objectives, and the power of the company, whereas the AOA regulates the relationship between companies and its members. Coming towards the relationship between company and the outside world, the MOA is a connecting point or the relation that's between the company and the outside world or the public. Whereas the AOA has a relationship between the company and its own members since it manages the internal management or it's the laws that govern the internal management. Coming towards the hierarchy, it's superior and it cannot be overridden by AOA. As we know, it's the charter or the supreme document, and so it cannot be overridden or overwritten by the AOA. And the hierarchy of the AOA is subordinate, must be consistent with the MOA, and it lies below the power of MOA. So alterations, we cannot cause, or rather, it's quite difficult to cause any, or it's very restricting to cause any alterations to MOS since it requires an NCLT or the National Corporate Law Tribunal or the government approval in most cases. Whereas in the AOA, it's relatively easier to cause any alterations. Only special resolutions required by section, it comes under the section 14 of the Companies Law Act. The MOA is, as we all know, the MOA is absolutely compulsory for a company to even begin or to start functioning. And in case of AOA, it's also required or it's also compulsory since no, I mean it's also required and compulsory, but in public companies it's very much compulsory, whereas it's optional for private companies. Model AOA applies to them. The consequences of MOA and AOA can be described as any act beyond MOA, any act beyond MOA is defined as ultra-vires, void or unratifiable or unrectifiable. Whereas any act beyond AOA, it can be seen as irregular but may be ratified by special decisions. Moving on to our next topic. The second part of our presentation would be the shares and the share capital, the capital structure, types, and management. So let's discuss what is a share. A share is a unit into which the company of I'm sorry, let me rephrase that. A share is a unit into which the capital of a company is divided. It represents the interest of a shareholder in the company and gives the holder a bundle of rights and obligations under the Section 284 of the Companies Act 2013. So we can describe shares as a unit that a company uses to divide its capital, and it's done under the interest of a shareholder. I'm sorry. It's done under the interest of a shareholder and gives a bundle of rights and obligations to him or her or them. There was a case in which Borland's trustee versus the Steel Bros Co. Limited. A share is the interest of a shareholder in the company measured by a sum of money for the purpose of liability and interest. So let's talk about shares a bit further. A share is a movable property. Shares are movable property transferable in the manner provided in the AOA. They cannot be bought, sold, gifted, or pledged to anyone. Every share of a company is limited or up to a certain number. Every share in the company must have a distinctive number for identification unless they are held in dematerialized or demat form. Each share has a face value. Each share has a nominal or face value of example of rupees 10, 100, or anything. Market price may vary, but face value stays constant unless altered by the company. So it's up to them if they want to change the face value. Otherwise, it stays constant, whereas the market price may vary. And the rights bundle that's given to a shareholder. So it can be stated as the owning a share gives right to vote, right to dividend, right to attend meetings, right to inspect books, or right to even receive notices related to the company. Then there are types of shares or share capital. It can be said as the authorized, issued, subscribed, or paid up capital. The authorized or the nominal capital could be stated as or could be defined as the maximum capital a company is permitted to raise as stated in the capital clause of MOA. The company cannot issue shares beyond this limit without formal amendment. So, as we read before, 10 lakhs is the maximum limit that a company can that a company is permitted to raise shares. And in any case they want to increase the limit, they have to make formal amendments into their MOA. Coming towards the issued capital, it's the portion of authorized capital which the company actually offers to the public or investors for subscription for subscription. So it's the capital that's issued towards the public or towards the shareholders, and the remaining authorized capital is unissued. Then we come towards the subscribed capital, which is the portion of issued capital that has been actually applied for and accepted by the investors. If oversubscribed, the some applications are rejected by the company. So it refers to the subscriptions given out by the company towards the investors or the people interested in buying their shares. And if certain subs are, if certain shares are oversubscribed, the company has the right to or it can reject those applicants. And we come towards the paid up capital, the portion of subscribed capital on which the company has actually received payments from shareholders. Amount called but not paid are called call in arrears. So it's basically the capital that has been paid for by the investors or the shareholders. Let's move further. Then we come towards equity shares or the ordinary shares. Equity shares can be defined as those shares which are not preference shares. They carry the residual risk and reward of the company. They are entitled to dividend and return of capital only after all preference shareholders have been paid. So they're basically the shares which are not, they don't come under the preference shares category. They carry their own residual risk and reward of the company. So in case there's a loss, they also have to face the loss, or if there's a reward or there's a certain profit, they'll also gain the benefits of that. And they're also entitled to the dividend and return of the capital only after the preference shareholders have been paid up. So the equity shareholders have voting rights. One share is equal to one vote if there's a poll for it, and it's proportional to paid up capital. And shareholders can vote on all resolutions. They have the right to elect board of directors for the company. They also have the right to remove directors, which comes under section 169. And moving towards the dividend rights, the dividend may not be fixed. It depends on the situation or the occurrence when it happens. And it's paid from distributable profits of the company. The board recommends and members approve how much dividend should be given to a certain group of people or the investors or the shareholders. It's declared after the preference dividend, and the unclaimed dividend goes to IEPF. Then coming towards capital and winding up, the last priority in capital repayment, it comes towards the lower end or the last, I mean, the at the end of the payment cycle of capital. After creditors and preference it is winded up after the creditors and preference shareholders have been cleared. And they may also receive surplus assets on winding up. And the return depends on the assets available of the company. Residual claimants or the residual claimants have the possibility of getting a higher risk and reward. The other rights that are obligated to the investor or the shareholder of these equity shares are right to the bonus shares of the company, right to right issues, preemptive rights on the new shares that the company might issue. It has a right to inspect statutory registers of the company, and it also has the right to sue the company for operation under Section 241. Coming towards the preference shares, these shares carry preferential right as to dividend at a fixed rate and repayment of capital on winding up before equity shareholders. They generally do not carry voting rights except for on the resolutions which directly affect their rights. So we can describe preference shares as we have the right to, or they have a benefit of receiving dividend at a fixed rate, having the repayment of a capital on winding up before the equity shareholders, like we previously discussed. But the catch is that they do not have a right to carry vote. They don't have the right to voting, except on special or exceptional cases where resolutions directly affect their rights. Excuse me. And some features of the preference shares can be described as cumulative. The unpaid dividends accumulate and are carried forward to the future years, and it must be paid before the equity dividend. It's non-cumulative in the sense if the dividend is not declared in a year, it lapses, not carried forward. So it's much more riskier than the cumulative. And participating, in addition to fixed dividend, entitled to share surplus profits of the equity shareholders after they receive their dividend. So basically, in addition to the fixed dividend, they are also entitled to share surplus profits with the equity shareholders after they have received their dividends. And it's non-participating in the sense that only entitled to a fixed rate of dividend, no right to share in the surplus profits or the surplus assets on winding up. They are redeemable in a sense where the company can repay the capital to the preference shareholders after a fixed period. Maximum redemption period is up to 20 years under the Section 55. And they are also irredeemable in a sense where it's prohibited to redeem them. Under Companies Act 2013, Section 55(1), all preference shares issued must now be redeemable. Let's compare equity shares with preference shares. On the basis of dividend, the equity shares are not fixed and depends on the profits and board discretion. Whereas on the other hand, the preference shares have a fixed rate and paid before the equity dividend is given out. They have voting rights. Full voting rights on all matters are provided to the equity shares, whereas on the preference shares, voting only when dividends are in arrears or on issues affecting that or in issues that affect their rights. Then there's priority in winding up. The priority given to the equity shareholders is on the lower or the last side, whereas preference shares get a priority over equity shareholders and are paid before them. And there's risk. Equity shares have a higher risk. Returns fluctuate, have a higher risk since the returns fluctuate with the company's performance. Whereas for the preference shares, the risk is on the lower end, and fixed return provides stability. Then coming towards capital repayment, residual claimants after all others are paid. So there is the people who want to claim can be that can only claim after all other of the claimants have been paid. Whereas in the preference shares, preference in repayment of capital, arrears of dividend, they cannot accumulate and there's no concept of arrears for them. Whereas in preference shares, the cumulative preference shares accumulate the unpaid dividends. Sorry. And uh, I'm sorry, sir. For some reason that's not visible. And let's discuss the issue obligation. It's mandatory for all companies. Everyone must have equity shares, whereas preference shares are optional and based on the company's capital needs. Moving forward, the members of a company, their rights, obligations, and registration of them. for them. So let's talk about who is a member and how to become one of a company. Its definition under Section 255, a member of a company is a person who has subscribed to the Memorandum of Association or has agreed in writing to become a member and whose name has been entered in the registry of registration of the members. So it's basically a person or an individual which has been subscribed to the MOA of a company from the beginning or has agreed in writing to become a member and whose name has been registered officially in the register of members. And there are three ways that a person can subscribe or can become a member of the company. The first one being subscriber to the MOA, a person who signed the memorandum of association at incorporation. They are deemed members from the date of incorporation of the company. Like I said, if they are subscribed to the MOA, they have membership rights from the beginning of the incorporation. Excuse me. Even if their names are not yet entered into the register, they would still be considered as the partners. And this is the original mode of becoming member. The foremost way of becoming member is to subscribe to the MOA. There's no allotment required. The MOA subscription is sufficient. And the second way is the allotment of shares. A person or individual applies for shares of a company and the company allots share to them. This technically makes them a member of the company as well. The membership commences right from the date of entry in the register, and they must accept all the allotments in writing, which is the letter of allotment. It's applicable during IPO, rights issue, and bonus issue. The company must enter name within 2 months of the allotment of the shares. Then there's the third way, which is the transfer of shares. Acquiring shares from an existing member via transfer, executed through Form SH4, which is the instrument of transfer used by the companies. The transferee becomes member on the entry in the register, and the board must approve and register the transfer. The board also has a power or option that they can refuse transfer only for valid stated reasons. And then there's the rights and obligations of the member. The rights of the members can be listed as the right to attend, speak, and vote at general meetings of the company. They have the right to receive notices of the meetings within the prescribed time. They have the right to receive declared dividend as per the shareholding. They also have the right to receive annual reports, financial statements. They have the right to inspect statutory registers of the company or the register of members or directors. They have the right to apply for operation and mismanagement done by the company or its members under Section 241. They have the right to participate in surplus assets on winding up. They also have the right to transfer or transmit their shares as per the company's AOA. And then the obligations of members could be listed as they have pay calls on shares as and when demanded by the company. They have to pay the interest on all calls in arrears at the prescribed rate. They have to abide by the MOA and AOA and the resolutions of the company. They cannot disclose beneficial interest in shares if applicable. They cannot engage in activities such as competing with the company if it's agreed. And they have to report any change in address to the company promptly. And they have to adhere to the restrictions on share transfer, preemption clause in the AOA. They have to participate responsibly in the shareholders' democracy. Moving forward, let's come to the registers of the members. Every company is required to maintain a register of members at its registered office under Section 88. It's a statutory register that serves as the definitive record of the company's shareholders. Excuse me. Let's talk about the content of registers. It should list the full name and address of the member. It should have the date mentioned since when they became a member of the company. It should have the number and class of shares held by the person or by that individual or the member. Excuse me. The amount paid and unpaid on each share should be mentioned as well. And the date of cessation of the membership or the end of membership should be also mentioned. And the right to inspect, all the members of that company have the right to inspect the members free of charge during business hours, the other in public on payment of prescribed fee. Inspection may be at a registered office. It cannot be refused without any valid reason by the company. The extracts must be provided on request as per the member's uh, requirement or his will. And then there's closure of register. A company may close register for up to 45 days a year under Section 90 or under Section 91. And the maximum number of the maximum number of days consecutive should be 30 days at a time. The advance notice of 7 days must be given to the members of the company. The purpose of closure of a book of a register is so that denying the members entitled to dividends notices, also called the book closure. And the penalties for non-compliance with the registers of with the register of members is are I'm sorry, failure to maintain failure to maintain of a register leads to penalty on company and officers. The wrongful refusal of inspection could be fined up to 1,000 rupees a day. The false entries or the fake entries is considered as a criminal liability under IPC, Indian Penal Code, and the ROC can direct inspection by the court order. Sorry. And the register is primary evidence of the membership, so it cannot be altered with or uh, you basically cannot alter it in a way which can cause legal implications or legal problem for the company. And we're talking about the transfer of shares and the transmission of shares. The transfer of shares process can be described as a voluntary act by which the holder of shares, the transferor, passes on the ownership of shares to another person, transferee, in exchange for consideration as per the procedure prescribed by law, which could be seen here. The first step is to execute the transfer deed. The transferor or transferee execute the form SH4, which is used as an instrument by the companies for the transferring, and it must be stamped with the appropriate duty and must be signed by both the parties before the process begins. Then there's step two. They should submit it to the company. The form or the transfer of shares should be known or should be submitted to the company. The transfer deed along with the share certificate delivered to the company must be submitted within 60 days of the execution of the transfer deed. And then there should be a board approval. The board of directors consider the transfer in a board meeting. The boards can refuse only for a valid reason stated in the AOA in case there are some unpaid calls, etc. Then there's step 4, which is the registration of transfer. On approval, the name of the transferee entered in the register of members, share certificate issued in the name of transferee within 2 months. Right. Moving forward, then there's transmission of shares. It could be stated or defined as the transmission is the transfer of ownership of shares by operation of law without any voluntary act of the members. It occurs due to the events such as death, insolvency, mental incapacity of a shareholder. No stamp duty is payable on the transmission. It's basically the transfership of ownership of shares by operation of law or lawfully and without any voluntary act of the members. It only happens under certain situations, as in death of a member which held the shares, or insolvency, mental incapacity, or of a shareholder. And there's no there's no obligation to pay the stamp duty for this transmission. In the first case, which is the death of a member, their legal hires, the legal hires, or the nominees they mentioned earlier are entitled to the shares, and they should have a death certificate as well as succession certificate The company cannot refuse transmission if the documents are in order. Uh, and there's a nominee. If he or she is registered, is the first point of claim, and there's no obligation to pay stamp duty, no consideration, or no transfer deed required in case of a death of a member. And then there's insolvency of a member. If official receiver assignee becomes, or the assignee becomes entitled to the shares, insolvency court passes an order vesting the shares in assignee, and the company must enter official receiver's name and register. The rights vest by operation of the insolvency law. The insolvent member loses all rights, including voting rights. Then there's the third scenario, which is lunacy or mental incapacity. The court appoints a committee of the person or guardian. The guardian submits the guardian submits the court order to the company. Company enters guardian names as person entitled, and the guardian manages shares on behalf of the incapacitated member, and the company cannot refuse if the court order is valid. So basically, they provide the incapacitated person with sort of a helper which helps in managing all their transmission or the transmission or managing their shares under court orders. Moving on. And the key difference between transfer and the transmission of shares. So now let's discuss about the transfer and the difference between the transfer and transmission of shares. On the basis of meaning, the transfer of shares are a voluntary act. A shareholder intentionally passes ownership to the another. And in case of transmission of shares, it's an involuntary act since the ownership passes by operation of law. The causes are agreement between the transferor and transferee in the case of in the case of transfer of shares, whereas in the case of transmission of shares, the causes could be death, insolvency, or lunacy of a member. The transfer of shares are voluntary and both parties must agree, whereas the transmission of shares are non-voluntary, involuntary, and it's automatic by law. No party needs to agree. They are in case of transfer of shares, it usually involves payment of a price. Whereas in transmission of shares, there's no consideration required. Gratuitous transfer. There's a there's a stamp duty payable on the transfer of deed on the transfer deed, form SH4. Whereas there's no stamp duty payable in the case of transmission of shares. The documents required for the transfer of shares could be the transfer deed, SH4, the share certificate, as well as identity proof for both the parties. In case of transmission of shares, the death certificate, court order, succession certificate, as well as share certificate are required. And the board may refuse for valid reasons stated in the AOA in case of transfer of shares, whereas in the transmission of shares, the board cannot refuse if valid legal documents are produced in front of the court. Moving on. Coming to our last part, the directors, the managing director, as well as the whole 10 director. So let's begin. The managing director or the MD could be legally defined as as the director who, by virtue of the articles of association, an agreement, a resolution passed by the company's board and or shareholders, is entrusted with the substantial power of management of the affairs of the company, not merely clerical or routine functions. So his or her appointment is done by the board resolution, then approved by the shareholders in next general meeting, by the central government, excuse me, by the central government approval required in some cases. And the term of office should be maximum 5 years at a time, can be reappointed for further terms, and there's no limit on total tenure under the Act. And the remuneration should be regulated by the Schedule 5 of the Companies Act 2013. And he or she is subjected to shareholder approval if limits are exceeded. There could be multiple MDs in a company. In case of multiple MDs, there cannot be more than one MD in a company. simultaneously, except where the other company is a subsidiary or a holding corporation. In case of disqualification, the undischarged, insolvent, convicted of offense, court restrained people cannot be appointed as MD. In case there is some insolvency, they have done some convicted offense, or they are court restrained, they cannot be appointed as MD. And the powers, he or she can exercise all powers of a board as delegated, and they cannot subdelegate except to the extent permitted by the board. And in case of removal, he or she can be removed by the shareholders before expiry of term, and they are entitled to compensation for loss of office, liability. He or she is personally liable for acts done beyond authority, responsible for regulatory filings and compliances. Moving on, in case of whole-time directors, they can be legally or they can be defined as the people or the individual who devotes his whole time to the company. He cannot hold any other employment outside the company during this tenure. Unlike a MD, he may or may not have full management powers. His primary obligation is full-time service to the company. So I think, as the name suggests, it's quite clear that it should be an individual that completely devotes all of their time towards the company. They cannot have any other obligations towards any other company or any other employer. His or her primary duty is to devote entire working time exclusively to the company, and no other employment permitted unless specifically approved. And their powers have no they have no automatic executive powers, and they depend entirely on delegation by the board of directors. The appointment is done by the board resolution, and it's subjected to approval of shareholders in the general meeting within 1 year under the section 196. Maximum 5 years at a time of the term in the office, and same as MD. And it's renewable on expiration. Central government approval may be needed in listed companies. In case of remuneration, it's governed by Schedule 5, same as MD, and it includes salary, per, per, perquisites, and commission and sitting fees. The difference from MD could be that an MD has necessarily substantial management powers, whereas the whole-time director only works full-time and has optional management powers. And it could be deemed as MD. A whole-time director may also be designated MD if granted management powers. Both titles also may coexist as one person. The accountability, the whole-time director is accountable to the board and can be held liable for breach of duty, non-compliance, or mismanagement. Moving forward, the main difference between, or the key differences between managing director as well and the whole-time director could be listed as following. The point of difference when coming towards the statutory definition is that under section 254, he or she is entrusted with substantial management powers, whereas the whole-time director under section 294 devotes whole time towards the company. The key characteristics of MD are possession of substantial management powers, whereas the whole-time director has full-time dedicated service to the company. And when it comes to management powers, excuse me, MD must have substantial powers since it's the defining feature, whereas the whole-time director may or may not have management powers. Outside employment cannot be MD of more than one company simultaneously, whereas the whole-time director cannot hold any other employment outside the company. When it comes to designation overlapping, an MD can also be a WTD if serving full-time, and vice versa, a WTD can also be designated as MD if granted management powers. And the focus of role could be that strategic management and decision-making for a managing director, whereas it could be operation and full-time dedication for a whole-time director. The appointment could be done by the board resolution plus the shareholders' approval for a managing director, and it could be said the same for the whole-time director, the board resolution as well as the shareholder approval. And to conclude our session, I would like to give a brief summary of what we've discussed in the presentation. The MOA is the supreme charter of a company, defining its constitution, the 6 clauses, the name, registered office, objects clause, liability clause, capital clause, and association clause. Then we're coming towards ultra vires doctrine. It acts outside the object clause are void. Any the acts outside the object clause are void and unratifiable. The MOA overrides AOA, and the AOA governs internal management only. The share capital hierarchy, the authorized shares are superior to or equal to issued shares, and issued shares are superior or equal to or more than or equal to subscribed. Same for the same for the paid up share. Each level reflects a different stage of company's capital mobilization. The equity shares have the equity shareholders have voting rights, residual dividend, and high risk reward, whereas the preference shares have fixed dividend, priority in repayment, and limited voting rights. And the next summary could be that members have extensive statutory rights, dividend, voting, inspection, and obligations, pay calls, they have to abide by the MOA or the AOA, and the register of members is mandatory in any company or every company. The transfer of shares should require voluntary stamp duty and the SH4, which is the transfer of shares document instrument, versus the transmission of shares, which is involuntary by law. It requires a certain case such as death or insolvency. It requires no stamp duty and the board cannot refuse. Then coming towards the directors, the MD has substantial management powers under Section 254, whereas the WTD or the whole-time director devotes his or her full time to the company under Section 294. Both appointed under Section 196, governed by the Schedule 5, and it also governs the remuneration. And all topics are governed by the Companies Act 2013. Understanding the MOA and the share capital is foundational to a company's law and corporate governance. So I would like to thank you for giving me this opportunity to present on such important topics that govern and control how a company works lawfully and legally. So I would like to conclude my meeting here. Thank you, sir. Again, my name is Deiveish, and it's been a pleasure to present these topics for you. Thank you.